Hello, my name is Natalia Willett, and I'm an attorney here in the state of Florida. And today we're going to be talking about divorce. And the topic of the day is modifications of parenting plans. This is something that I see all over social media. People have quite a bit of misconceptions about what entitles them to make changes to the parenting plans that the courts have created. And so I wanted to go over what is required in Florida in order for a parenting plan to be modified by a court if the parties have not agreed to the modification. And by parties, I mean mom and mom, dad and dad, depending on your circumstance. So there are four things that must be shown. One, that this modification is due to a substantial change in circumstances. So the fact that your ex-husband moved 15 minutes from your son's school, now the drive is 45 minutes, is not a substantial change. Two, the change must be material. So material means it really is impactful to your child's life. For example, the fact that your significant other now has a roommate that is a registered sex offender, that would be a material change in circumstances. Number three, unanticipated. Okay, so this means that the change in circumstances was not anticipated. So if you and your husband have lived an hour from each other and you've got 50-50 time sharing, and that means that your kid's gonna get a hour drive to school versus 5 minutes at dad's house, that was not an unanticipated change in circumstances. It's something that was foreseen. The parties lived in the same place, and therefore it's not going to be open to a modification because, well, with this parent, the kid has to have this kind of a drive to school, and with this parent, the kid has to have this kind of a drive to school. That's not unanticipated. So it's got to be substantial, material, and unanticipated change in circumstances that lead to requesting the modification. And then finally, it still has to be, no matter what, in the best interests of the child. So the time sharing changes that you're requesting have to be in the best interest of your children. That means in the best interest of your children. And why am I repeating this? Because so many parents think, oh, well, it just suits me better to have this kind of time sharing thing, blah, blah, blah. I have to drive less. No, that sounds like it's in your best interest, right? So the court does not care if it makes it slightly less convenient for you that something has changed. They care about what's in the best interest of the child. And you go back to those 20 factors that the court weighs, and any other additional factors about what's in the best interest of a child when it comes to spending time with both their parents. So if you like this video, if you find it to be of value, you should definitely subscribe to our channel. And then remember, divorce is not the end, it's a new beginning.